Good morning, this is your Kelso Report for Thursday, March 14th, and I'm your host, Clark Kelso. Well, today we take a look at the Ninth Circuit, which granted in-bank review in a prisoner's civil rights case involving exhaustion of remedies. It also issued a preemption decision involving airlines and accommodations for persons with disabilities, and it issued a habeas decision involving younger abstention. Meanwhile, we have a state court decision emphasizing the perils of prematurely trying to appeal a non-appealable order. Let's begin with the Ninth Circuit. As we have seen in lots of cases, courts really go out of their way to help inmates without lawyers through the maze of court processes. But a split-panel decision of the Ninth Circuit last September in Albino v. Baca suggested that there are limits to everything. In Albino, an inmate complained that the jail's failure to relocate him to protected custody ultimately led to his being attacked and raped by another inmate. He filed an action in federal court, but the action was dismissed because he had failed to exhaust his administrative remedies. He claimed he was unaware of the jail's grievance procedure and therefore did not need to exhaust. A majority panel of the Ninth Circuit disagreed, holding that an inmate's lack of awareness of a correctional institution's grievance procedure does not make the administrative remedy unavailable for purposes of the Prison Litigation Reform Act, unless the inmate meets his or her burden of proving the grievance procedure to be unknowable. Well, the plaintiff in this case did not meet that high burden of proof, so the Ninth Circuit affirmed the district court's grant of summary judgment. The full Ninth Circuit has now voted to take the case in bank. So apparently there are quite a few judges out there who think, well, maybe we should not be insisting upon procedural regularity here, and instead, as is often the case in prison litigation, we should give the inmate some special consideration. We'll see which side the court lands when it issues an in-bank opinion, probably sometime later this year. Well, now we turn to a case involving the Americans with Disabilities Act and airlines. The ADA was enacted in 1990 to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. Title III of the Act prohibits discrimination in public accommodations, but the definition of public accommodations expressly excludes terminals for transport by aircraft. As a result, the Department of Justice interprets Title III as not covering the operations of any portion of an airport that are under the control of an air carrier. Those areas of an airport are instead covered by the Air Carrier Access Act, which contains its own specific regulations regarding providing assistance to travelers who need and request it. In Gilstrap v. United Airlines, a passenger was not provided the requested assistance of a wheelchair to assist her in making a connecting flight. She also alleged that United agents yelled at her, expressed skepticism that she needed a wheelchair, and twice directed her to stand in line, which she could not do because of her osteoarthritis and other health problems. She sued under various state law tort theories and under Title III. Now, the Air Carrier Access Act does not itself provide for a private remedy, but the Act, along with the implementing regulations, are very specific about what airlines are required to do. And in light of those detailed standards of care, the Ninth Circuit held that the federal standards preempted the field with respect to the standard of care, but that state law tort remedies for a violation of those standards was not preempted, splitting the baby. In addition, the court held that state law was not preempted with respect to claims based on how the airline agents interacted with passengers with disabilities. So screaming at the passenger is not something that is preempted by federal law. If there's tort liability for it, so be it. Interesting decision on preemption there. Next, we have a younger abstention case from the Ninth Circuit. California's Sexually Violent Predators Act permits the state to hold an inmate after his criminal sentence has expired based on a showing at a civil commitment hearing that the inmate still remains a threat to public safety. In Knight v. Allen, the Ninth Circuit considered a habeas petition by a petitioner whose criminal sentence had expired in 2004, but who had been held in custody pending his civil commitment trial. The state had filed its Sexually Violent Predator Act petition, but there then were a series of lengthy delays, some based on the petitioner's requests for new counsel, some based upon stipulated delays, and some based upon simply the state's failure to bring the petition to trial. It sort of got put on the back burner. Well, ultimately, the petitioner filed a petition for habeas corpus. The district court dismissed the complaint under the Younger abstention doctrine, pursuant to which a federal court will dismiss an action where there is an ongoing criminal proceeding in which the federal issues may be raised. The Ninth Circuit reversed, concluding that as a practical matter, the state proceeding was not ongoing in the relevant sense. Instead, it was dormant. Based upon the Attorney General's representation that the state could hold a hearing on the petition within 90 days, the Ninth Circuit remanded with instructions to require the hearing in 90 days. After 8 years being held while awaiting the civil commitment trial, it is long past the time to get on with it and hold the hearing. Speaking of limits to a court's patience, which is where we started tonight in the in-bank for the Ninth Circuit, we now have a Court of Appeal decision from the 3rd District dealing with limits on the court's patience in issues of appealability. California state courts follow the final judgment rule, pursuant to which appeals ordinarily may not be taken from interlocutory orders, and only the final judgment in the action is appealable. In federal court, that issue is jurisdictional. Well, in state court, the rules actually do give the appellate court some discretion to permit a premature appeal from a non-appealable order to be treated as timely filed after the ensuing final judgment is entered. But as the 3rd District said in Good v. Miller, there is a limit to our willingness to salvage appeals for parties who ignore the statutory limitation on appealable orders. In this case, the trial court had issued a discovery order against the plaintiff. When the plaintiff willfully ignored and violated that order, the court granted the defendant's request for monetary and terminating sanctions and issued an order granting that motion. However, that order was not appealable because it was not a final order dismissing the case. Nevertheless, before that final order had been entered, the plaintiff appealed from the order granting the motion for terminating sanctions, even though the case law is perfectly clear that such an order is not appealable. Well, in this case, the 3rd District refused to exercise its discretion to save the appeal because the appellant did not ask for such discretion to be exercised, completely ignored the appealability issue on appeal, and actually misstated relevant facts in the appealability section of his briefing. The lesson is clear. If you make a mistake and appeal from a non-appealable order, own up to the mistake and ask for the court to exercise its discretion to save the appeal. Don't stubbornly ignore your error. The consequences can be fatal. And that's it for today's Kelso Report. Have a great day in the law.